Good morning, Sasha.
Good morning.
All right. Good morning, everyone. Hope everyone is doing well. Welcome to our second official Commission Zoom meeting. We'll go ahead and begin. Ms. Linker, why don't you go ahead and call the roll?
Commissioner Cardenas?
Here.
Commissioner Hatch?
record will reflect that we see Commissioner Hatch.
Commissioner Hayward,
Here.
Commissioner Wilson,
Here.
Chair Matich.
Here. All right, we'll go ahead and proceed with item number 1, public comment for items not on the agenda. Do we have any public comment for items not on the agenda, either through the telephone or through our digital public participation site? Seeing and hearing none, we'll proceed to item number 2, approval of commission meeting minutes from our April 2020 commission hearing. Do any commissioners have any edits or comments for the meeting minutes?
I do not.
Hearing none. Do we have any public comment on the meeting minutes? Seeing and hearing none, do we have a motion?
I'll move approval.
I'll second that, Mr. Chair.
Thank you. Ms. Linker?
Commissioner Cardenas,
Yes.
Commissioner Hatch,
No vote.
Commissioner Hayward,
Yes.
Commissioner Wilson,
Yes.
Chair Matich.
Aye.
The motion passes.
Thank you. We'll proceed to item, our enforcement consent calendar. With respect to the enforcement consent calendar, I wanted to let everybody know that I intend to recuse myself from the consideration of item number 4. I'm doing so in an abundance of caution. At a point during the time that I was in private practice several years ago, I did represent the city of Upland. It was not connected to this matter as far as I can tell, but in an abundance of caution, I'm going to recuse myself from our vote on item 4. Do other commissioners have any of the enforcement consent calendar items that they wish to pull? Hearing
Is the
and seeing
sound on?
none. Commissioner Hatch, did you have a matter you wanted to pull?
Chair Matich, I'm
All
not
right.
sure he knows that we're meeting.
All right, hang on one second. We're going to have Ms. Linker try and contact Commissioner Hatch to make sure he is able to hear us. So we're going to take a short break.
Hello, how are you?
Commissioner Hatch, are you able to hear us?
I now can hear you.
Excellent, excellent. All right, we'll go ahead and reconvene here. So, Commissioner Hatch, we are on the enforcement consent calendar, items 3 through 12. I indicated that I'm going to recuse myself from item number 4 in an abundance of caution because I previously represented the city of Upland. The question to the commissioners is, do any commissioners have any items on the enforcement consent calendar they want to pull for special discussion? All right. I would like to have a brief conversation about item number 3. So perhaps what we can do is let's go ahead and take up items 5 through 12. Do we have a motion to approve items 5 through 12 on the consent calendar?
So moved.
Second.
Is there any public comment on items 5 through 12 before we proceed with the vote? Hearing and seeing none, Ms. Linker, please call the roll.
Commissioner Cardenas,
Yes.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Aye.
Commissioner Wilson,
Aye.
Chair Matich.
Aye.
The motion passes.
All right. At this time, I'm going to leave the dais, and I would ask Vice Chair Hayward to conduct the vote on item number 4, please. Thank you.
He's the only one of us that can actually leave a room.
Yeah. How do we do that?
Duck under the desk, I think. All right. Is there any discussion on item 4? That's the City of Upland matter.
No, Madam Chair.
I do not believe I can tell if there's any public discussion, any public input from my vantage point. Can somebody there in the hearing room confirm whether or not there's any public comment on item 4?
Commissioner Hayward, I will unmute the telephone right now, but we do not have any digital public comment.
Okay, I don't hear anything on the phone, and Ms. Linker has confirmed that there's no digital, so let's move to a vote. Ms. Linker, can you call the roll?
Can I get a motion, please?
Oh,
I'll
that would be good. Sorry. We've got a motion moved and seconded.
Commissioner Cardenas,
Yes.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Aye.
Commissioner Wilson.
Aye.
The motion passes.
Now, if the Sergeant at Arms could go get the chair.
Thank you, Commissioner Hayward and others. So for item number 3, the reason I wanted to pull that for a separate discussion is because the counts in this matter and the matter itself pertain to an issue that I know we've talked about as an area of focus for the commission, and that is when public agencies use public monies to engage in campaign activity, which is both unconstitutional under our state law, under the Stanton versus Mott line of cases, and also as a consequence of that unconstitutional activity triggers violations of the Political Reform Act, which are within our jurisdiction and are the subject of this particular enforcement proceeding. The reason I wanted to pull it is to draw the commissioner's attention to the fact that for item 3, the penalties that enforcement is recommending in this particular matter are, in my view, on the very low side. I think if you examine some of the counts, the per count penalty in some instances is just $500, even though this is, again, the commission has expressed in the past that the misuse of public funds is among the most egregious violations of the act and worthy of heightened penalties. It's also the subject of a prior legislative effort by our agency to obtain greater enforcement authority because presumably we don't believe that $5,000 per count is sufficient. I am, having said that and drawn that to the commissioner's attention, I also believe that in my mind at least, the most prudent approach to this issue for us is a 3-pronged strategy, which includes first trying to clarify the standard for public agencies so that they can understand very clearly where the line is with respect to impermissible campaign activity. And we are in the process of doing that, so we haven't completed that task yet. The second prong would be to bolster our public outreach and education efforts so that once we have clearer rules in place, we can assist local governments in complying with them. But then the third prong would be, at some point, hopefully in the not too distant future, to, as a matter of policy, have enforcement levy higher fines in these types of cases, because again, I think they really do strike at the heart of public trust in government. So I'm willing to support this stipulation. I know our enforcement division works very hard at getting these stipulations. These are complicated cases, but I did want to draw that to the commissioner's attention, that the per count penalties here are pretty low. So with that, I will step down from the soapbox. My colleagues can have their piece.
Mr.
Do I have a
Chair,
Commissioner Cardenas?
thank you, Mr. Chair. I want to align myself with the chair's comments and congratulate him for taking this this opportunity to send a message, and also the balanced measure with which the chair is proposing that we approach this, to keep the stipulation as it is, but also to recognize that our historic up to this point determination of what kind of financial penalty is appropriate, given the gravity of the underlying issue here, which is the misuse of public funds and the misuse of public trust, balanced with the knowledge that we will have higher fines once we establish a greater clarity on what the standards are, to be fair to all parties concerned. And also, once we also get the word out in a concerted educational effort up and down the state to our partners at the local level on what the standards are and what the penalties are likely to be. We've seen a lot of press in the last year, as we know, on this particular issue with good reason. And so we should all take heart that that this commission under this chair is taking notice of these types of transgressions, and we're going to be adding clarity, transparency, and a stiffer penalty on these types of transgressions in the future. So, Mr. Chair, I appreciate the opportunity.
Mr. Chair. Mr. Chairman? Mr. Chairman? Fuck.
Commissioner Hatch is trying to be recognized. Can you hear us?
My mic seems to be muted or something.
No, I can hear you.
Oh, can you? Okay.
Yeah, they can't hear us now.
Brian, I recognize you.
Okay, thank
You
you.
look the same to me.
Thank you, Frank. I just wanted to, I don't know if the rest of the world.
I don't think they can hear us.
That's weird.
Yeah. Who's the hearing room host? We need to.
Yeah. Can you hear me?
Yeah, I can hear you just fine.
I'll send a message in the chat.
Yeah, send a message. Yeah, no, Rich just said Rich just sent me a text saying that he can't hear us.
Well, far be it from me, after just having sung the praises of the leadership of our chair, to suggest a mutiny, given that we have quorum.
Do you suppose he even heard it?
I never said it. Cardenas isn't even here.
Testing. That's weird.
It is weird. So how is everybody?
Still surviving.
They said they're dialing back in.
Oh yeah, it says connecting to audio.
Brian, you taking advantage of the sun, man?
I do. I take my little walks in the sun. It's about a moment of sanity.
Yeah, I hear you.
I never thought I'd look forward to grocery shopping, but I do.
I know,
No
isn't
kidding.
that funny?
No kidding. Yeah,
That's my big trip each week.
yeah.
It's the highlight of my week too.
Yeah. With my mask and my rubber gloves.
Okay, Sasha's holding something up. Technical difficulties.
Oh,
Well, she has better handwriting than I do because I can read that actually.
Uh,
Well, we seem to.
Grocery shopping and gardening.
It seems like in down south, Southern California, Central and Southern California, you could establish your own quorum down there.
That's true.
The hearing room's on mute.
Secession.
I nominate the capital of our new place to be Cambria because it's really nice here.
Yeah.
Well, fortunately, we're not in Berkeley as the state capital. I don't know if you know the history, but back around 1920s, there was an initiative on the ballot to move the capital from Sacramento to Berkeley. It obviously failed. But any of you who are familiar with the East Bay, there are a number of streets in North Berkeley, Albany, that are named after counties. And that was part of the city of Berkeley's, part of their campaign effort to move the capital to Berkeley.
Didn't know that.
Commissioners,
yeah.
can you hear us now?
Yes.
Now we can.
Well, that was
All
my
right.
Okay.
Can you hear
Mr.
us?
Chairman.
Sorry about that, guys. We had a technical difficulty. I could not hear you, and I don't think you could hear me. So I heard the beginning of Commissioner Cardenas's comments, and then it went. I couldn't hear anything else after that. So
So you missed the last 20 minutes.
pretty much. So would you like to summarize your comments again, please, Commissioner Cardenas?
No, I trust it's on the record. This is an important matter. The press has been aware of this. We are aware of it. We're going to leave the current stipulation as it is. To be fair, we know that we need to add clarity to the standard here, and we're going to provide further education to our local partners up and down the state on what the standard happens to be. And then, having done that, we're going to do the appropriate thing. We're going to affix financial penalties on the misuse of public funds and the public trust, commensurate with the public's concern about what's going on. Thank you.
All right, thank you. Do other commissioners wish to comment on item 3?
Yes, Mr. Chairman.
Commissioner Hatch?
Yes, thank you. I just wanted to call to the public's attention that we still don't have the duty or the power to enforce expenditures of public funds for political purposes. We can only hold them to the current standards that apply to all other spenders in the regulated community. And we also have a duty of fairness to apply this equally to all those. So we can't go crazy and try to superfine these folks because we don't have the power to do the other thing.
Do other commissioners have additional comments? Commissioner Wilson?
Well, I defer to the vice chair first.
Commissioner Hayward?
And they said chivalry is dead. Yeah, I guess the only sort of picky thing I want to bring up, and maybe this will help Galena in the future, is actually the per count penalty is pretty high. It's the way the violations were grouped as counts that I think maybe yields the lower penalty than what the chair would prefer. Because I'm looking at the STIP now, and count 1 involves mass mailings, 5 mass mailings. But that's only grouped as one count. Count 2 is 4 newspaper advertisements, grouped as one count. Anyway, my point is, maybe if we could make it clear on the record that Galena has our instruction to group counts differently and thereby yield penalties that are more in line with what we think is appropriate, then she can take that back to her office, and when she deals with people in the future, she'll have that to show them. That would be my suggestion.
I agree.
I think that's a good point. Ms. West, do you feel constrained by prior expressions of commission policy to require the grouping of counts this way, or was this a decision that you made sort of in your own discretion?
Hi, everybody. Galena West, Chief of Enforcement. This was more about, there's not a lot of prior cases that we have to go on. So we were trying to test the water because this case is unique in that it's not about a bond measure, a tax, or something where there's the big financial benefit, which is what we've all been discussing up until now. This was about a non-binding advisory measure. So for us, we were trying to balance these new criteria when you have a new fact pattern to what the general criteria the commission has set up to now. So that's why you see the bundling of the counts in this case, because it was 2016 activity, which is one of our flagship earlier cases that we're trying to figure out what is the correct penalty structure for these. So we really appreciate the guidance from the commission in order for us to move forward negotiations. And a lot of negotiations are for the same time period. So we have to have some sort of guidance as to what a proper settlement is going to be considered for something that happened the same time this happened, as opposed to new activity that they could have learned from this case and set the standard. So that's kind of the considerations that we were taking into a little bit different in this case, which is why we did the grouping.
Thank you. Thank you, Ms. West. Commissioner Wilson, I think you had a comment as well.
Yes, Chair Matich. I appreciate the comments by the commission members who obviously have more experience on this issue than I do. But I would say that from my perspective, I think it's important as we move forward and address the issues that have been outlined by the commission, that we look seriously at how we go about educating and training local government, school districts, water districts, to make sure that they are up to speed on the law, given some of the ambiguity with regard to existing statutes and regulations that govern how we conduct business. The education component, from what I can tell, is important to approach as we move forward on this issue. And then I have one technical question for Chief of Enforcement West. When it comes to the $14,500 fine, will that be paid out of the campaign committee? Or if there's not sufficient funds to pay the fine, would individuals who are in violation of the act be subject to paying some of those fines out of their own pocket?
That's a good question. So in these cases, they didn't establish campaign committees, which is what the violation is about, that they had activity that caused them to become a campaign committee. So they don't have an existing committee regarding this situation. And these types of committees, actually at every calendar year, they terminate automatically. So even if they had established it, it would be gone. So this, we're talking about it coming out of the city itself, or in this case, the water district itself, the public entity. And we did not choose to name anyone individually. So we did not attach individual liability.
Okay, just one quick follow-up question. But you do have that discretion, at least I'm sensing that from what you said, that if you wanted to, based on your investigation, fine an individual, whether it's an elected official or a high-ranking staff person, you would have that authority.
Certainly if they have duties under the act. So what we're tied to is if someone is paid for certain services or that cause them to fall under the very specific statute, those are the people that we can prosecute. And public officials are generally people that have filing obligations. So yes, they are people that could be prosecuted under the act. And how we determine that, if we're going to also charge the individuals, is we look for overt activities. We look for people that were the responsible ones pushing forward something that possibly we can prove intent, that they had some sort of intent to break the law in order to fulfill whatever purpose they wanted to fulfill. So we're looking at people that more are the impetus of the violation when we're doing personal liability, because it is a serious thing to do.
Okay, thank you.
All right, thank you, commissioners. Unless commissioners have additional comments at this time, we would move to public comment on item 3. Do we have any public comment on item number 3? Hearing and seeing none. Do we have a motion on item 3?
So move.
Second.
We have a motion and a second. Ms. Linker, would you call the roll, please?
Commissioner Cardenas,
Yes.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Yes.
Commissioner Wilson,
Aye.
Chair Matich.
Aye.
The motion passes.
Could I ask a follow-up question?
Yes, Ms. West.
Okay, so the commission's direction is that perhaps the grouping is a little too grouped in this case. So are we also talking about violations that happened during the same time period, or are you talking about future violations? Is this something that you want to see less grouped as we move forward, or more what Commissioner Cardenas was talking about after we do more education efforts? I just want a little bit of clarity for the other violations that are still in the process for the same time period.
Well, speaking for myself, Ms. West, I think it was important to clarify that you are not constrained or bound by the grouping, so that you have, at least in my mind, the discretion to not group when you find it to be appropriate. And so, at least from my perspective, what we're communicating to you is, if you, in the course of your investigation and your job, determine that there's a particularly egregious case in this area where you don't think grouping is appropriate, that you should feel free to do that and present it to us, mindful of the fact that this is an area that the commission thinks is particularly egregious. And
Okay.
that's my sort of my take on it. I don't know if commissioners have a different perspective on it, though. Commissioner Hatch?
Yeah, it's my considered opinion that we should not group them unless there's a really overriding reason to do so. In other words, that becomes our default as we approach the violator in a settlement. We should start with no grouping.
Okay.
Commissioner Hayward?
Yeah, I would agree with Commissioner Hatch. I think I'm usually reluctant to overturn the negotiated STIP, just because I know that they're the product of negotiation. But I do feel like even though in 2016 we weren't looking as closely at this issue, it was still illegal, and there still were committees, and a good lawyer would have understood that this was something that was improper for them to be doing. And so I want you to have more arrows in your quiver when you negotiate. And so that's really my perspective.
Okay. I appreciate the clarity. That helps us, and it helps us in our further negotiations with the current cases.
All right. Thank you, Ms. West. Thank you, commissioners. All right, we'll now proceed to item 13, and this is a pre-notice discussion of proposed update of commission regulations due to the enactment of Assembly Bill 902 and Assembly Bill 903. These are technical, non-substantive revisions to harmonize our regs with statutory changes. And I understand that we have Commission Counsel Matthew Christie here to present on this for us. Good morning, Mr. Christie.
Good morning, Chair and Commissioners. Matthew Christie on behalf of the Legal Division, here to present pre-notice discussion of a technical and non-substantive update to the Commission's regulations in response to changes to the Political Reform Act made by AB 902 and AB 903, both of which were sponsored by the Commission and enacted last year. In order to ensure consistency with changes to the Act made by those bills, the proposed update would revise Commission regulations relating to campaign disclosure and make the existing definition of street address applicable throughout the Act. The proposed update would also harmonize Regulation 18431 with recently issued advice, which clarified that although a payment by a vendor or sub-vendor to an individual that provides canvassing, door-to-door solicitation, or signature gathering is a reportable campaign expense, the vendor or sub-vendor is not required to report the name of the individual. Changes to specific commission regulations are explained in greater detail in the memo for the proposed update, and I'm happy to receive feedback and direction from the commission and to address any questions. Thank you.
Thank you, Mr. Christie. I see Commissioner Hatch has a question for you.
Well, thank you, Mr. Chairman. My focus was on Reg 18431.
Yes.
And it's on page 3, which is the language I think you were referring to towards the end of your statement. I just want to be clear. Is this the legislature's doing in this most recent bill that neither the candidate or its committee or the political consultant or anyone else who works for sub-vendors to the consultant would be required to report the people who actually do the canvassing?
So I want to make sure I understand your question, Commissioner. The changes to Regulation 18431 were actually made in light of recent advice that we've issued, not the legislation that's also involved in the debate. But with that said, when interpreting the provision at issue in that advice, we were looking to constitutional law and trying to see what the Supreme Court had allowed with respect to disclosing the names of individual solicitors, canvassers, or signature gatherers.
Is that it? Okay. Canvassers, especially those who are gathering signatures for petitions, have a fairly poor reputation in terms of conduct. And same with the voter registration drives. Often you get people who have no conscience about just filling them out themselves and signing them. And if no one can find out who these people are, how are we going to pursue the enforcement of the law?
I think that's a very good question, Commissioner. And because it is a policy question, I wanted to make sure that I defer here to Council Dave Bainbridge.
Okay.
Mr. Bainbridge, do you wish to speak on this issue?
Well, I understand Commissioner Hatch's point, but here we're just trying to make our reg interpret in a way that's consistent with what the Supreme Court has said in the Buckley case, which is you can't require the name of individual signature gatherers. Now, the information that you would still get is what consultant or company was paid by the campaign, who then paid the individual signature gatherers. So if I go back to my enforcement days, I think an investigator could work through the vendor who had been reported to get information about who they had then paid to circulate the canvassers. This just wouldn't require disclosure of those individuals' names on campaign statements.
Well, does that then mean that they don't need to keep a record of it?
Are you talking about the committee?
The committee or even the sub-vendor, because they're mentioned as well.
Yeah, the committee would not need to keep a record of the individual names. I don't think there's any requirements of the sub-vendor of who they pay, but that's probably a better question for one of our auditors.
Yeah, because here's the thing is, if no one keeps a record of who these people are and there's bad things have happened and we're trying to find out who to punish, there needs to be a record, else there's no crime, as they say.
Commissioner Hayward, I see you have a comment.
Two thoughts. First, I think the individual piece of paper petition has a space at the bottom for the circulator's name. Okay, so they put in a fake name. That's a crime. Secondly,
But
these
you
people
can't
are
find
being
it.
paid, right? So there's a
Pardon?
1099 somewhere with their name on it. So, you know, it's not as though FPPC reporting or Secretary of State reporting is like the only place that a person's name is going to be. I was actually really pleased that the legal division took this on when Mr. Sutton mentioned that our advice to him was unconstitutional. And I was really pleased to see that the legal division was moving quickly to make sure that our regs reflected this, so it wasn't just one of those sort of underground regs that only existed in an advice letter. You know, I mean, you can disagree with what the balance that the Supreme Court struck between people's, you know, political liberties and whatever enforcement interest the state had in the Buckley case, but you know, they said what they said, and we don't have the power to demand that people disclose something that the Supreme Court has said is private.
With those cases where they were doing it on a volunteer basis?
Commissioner Hatch, in those cases at issue in Buckley, it was paid signature gatherers that were, or volunteer signature gatherers, but under the Colorado law at issue, they were forced to wear ID badges that identified them. And that was seen to squelch their First Amendment rights.
So it's not quite the same.
Well, the holding that Commissioner Hayward was talking about is correct. The situation in which it was applied in that case is a little bit different, but yes.
Could we not require that the vendors keep a record for a specific amount of time, our usual 10-year requirement that they keep a record of that, so that if we want to pursue it in some case, we can get the information? If they're not required to keep it, and they're not required to report it, it won't be there when we want to pursue it.
What violation of the act are we concerned with individual paid signature gatherers engaging in, Commissioner Hatch?
Well, false signatures is somebody's responsibility, and those who are in charge of making them happen, whether it's the campaign or the consultant or the sub-vendor or even the individual, that's a violation of the act.
I think that might be a violation of the elections code provisions, but Mr. Bainbridge can correct my recollection on that.
Yeah, I think that's right. That's an elections code issue.
Do other commissioners have additional comments on this? Commissioner Wilson?
Yeah, first of all, I want to commend General Counsel Bainbridge and Mr. Christie on their extensive work on this particular item. But just for the benefit of the public, it would be helpful if you could just give a brief description of AB 902 and AB 903, and specifically the benefit of additional action by the commission.
Sure, I'd be happy to, Commissioner Wilson. So AB 902, again, was sponsored legislation by the commission that was enacted last year. It did predominantly, it codified existing commission regulations relating to campaign disclosure. However, there were a couple provisions that were a little bit more involved. Most important one being changes that were made to the act to accommodate the completion of Cal Access replacement program that's currently underway, being administered by the Secretary of State. In light of that, the legislature made changes to section 84223 and some of the processes that trigger reporting or updates to top 10 contributor lists. It's not an extensive overhaul of those processes. There was just a minor change where there was a $5,000 threshold inserted into those processes for an additional contribution by a contributor already listed. that's a trigger for updating the list under the regulation. And the $5,000 threshold was inserted just for the period during the completion of the CARS project. With respect to AB 903, that bill did a couple things, but the only matter that's pertinent to the regulation package before you is an update of our regulation that defines street address for purposes of the act. That regulation was only applicable to Chapter 4's campaign disclosure provisions. And because some of the statutes that were touched in AB 903 use that term in a context outside of Chapter 4, we're trying to apply that definition throughout the act for greater consistency.
So thank you, Mr. Christie. So these changes are for the most part technical then?
Yes, very much so. They've all already been enacted into law, and this is just a matter of ensuring that our regulations are consistent.
Okay. Well, when I read this legislation online, you did a much better job in terms of explaining what it does. So thank you.
Thank you, Commissioner.
All right. Do we have any additional commissioner comments or questions for Mr. Christie or Mr. Bainbridge on this? All right. Do we have any public comment on item 13? Seeing and hearing none. This was our pre-notice discussion, so this will come back to us in July. Is that correct, Mr. Christie?
Yes, Commissioner. Excuse me. Yes, Chair.
Thank you, Mr. Christie. We'll see you in July, I'm sure. Oh, sorry, Commissioner Hatch, you have one additional comment?
Yeah, I would just urge that consideration be given to modifying the record-keeping requirements to assure that the information is preserved should it become an issue in an enforcement case.
We'll definitely take that feedback into consideration, Commissioner Hatch. Thank you.
Thank you, everyone. All right, we'll go ahead and move on then to item number 14. So update on the Digital Transparency Task Force. This is Vice Chair Hayward and myself, along with the other task force members, met last month for the first time. We had, I would say, a lengthy meeting. I think it clocked in at about 3.5 hours, but we were only scheduled to go 2 hours. So we had, I think, a lot of good information, both from our staff, from other agencies, both from other states, Washington, from LA City Ethics about their digital ad archives and other folks. And our next meeting is scheduled for next Friday. So we'll continue the discussion next Friday. Commissioner Hayward, did you have any comments about our inaugural task force meeting?
No, it was lengthy, but it was very informative. I'm hoping that most of the task force participants stayed for the whole thing or watched the recording later, because there was a lot of good information there and a lot of, well, not a lot, but several frank exchanges of ideas that I think helped sharpen some issues. I'm anticipating that our next meeting won't be as long because it's rather focused. And so to the extent that any of our task force participants are listening to us now or watch this, please call in next Friday and we'll get moving on some of the first questions that we've been presented with.
Great. Thank you, Commissioner Hayward. All right, we'll go ahead and move on then to item 15. This is our legislative report. We have General Counsel, Mr. Bainbridge, and our Communications Director, Mr. Waringa. Gentlemen, you can figure out which one of you wants to go first.
I believe Dave and I flipped the coin, and I won or lost, depending on what you think. Good morning, Chair and Commissioners. Jay Waringa, Director of Communications, along with General Counsel Bainbridge. We are your interim acting legislative team here to give you this update. As noted at last month's commission meeting and subsequent to that, we have received even further confirmation that for the most part, the only legislation that will move forward this session is related to the budget, to COVID-19, to wildfire preparation, census and election-related items. So those are the only things expected to progress, but we do have one bill remaining where we have not heard specifically from the author, as well as one item that has changed and another that did actually move forward. So I'll begin with the one that moved forward, which was AB 2151, the Assemblymember Gallagher bill regarding local campaign filings. It passed Assembly elections and then moved to appropriations. But again, we are getting feedback that it is not likely to move past that point. SB 300, Senator Umberg's bill regarding foreign contributions. We have not heard specifically from the author's office yet on the senator's intent with that, but that brings me to our other Senator Umberg bills, SB 423 on committee bank accounts. Senate staff informed us on the day the bill was gutted and amended on May 5th that they were going to do that, change it to an elections related bill. So staff, since the commission had taken a sponsor position on that bill, on the original bill, and as it is now amended, it does not concern matters within our jurisdiction. So staff recommends the commission remove its position as sponsor. And again, as I said, everything else is likely to stay where it is. And I'll turn it over to Dave to see if he has any additional comments and then open it up for questions if you have them.
Yeah, I don't have anything to add at this point, but happy to take any substantive questions. And at some point, we should take a vote on whether to remove our sponsored position on SB 423. I assume we go to a no position, but probably Commissioner Hatch could advise us on how best to change our position for that.
All right, thank you. Do other commissioners have questions or comments for either Mr. Waringa or Mr. Bainbridge? Commissioner Cardenas.
Thank you, Mr. Chair. Could I just, could we just hear again the current status of SB 300?
The current status, let me take a look here. We gave an updated ledge report this morning. It is basically in assembly elections where it has been since May of last year. And the senator's staff, we have reached out, I've reached out, and they have not indicated the senator's intent on trying to take any action on that. And given that both Assembly and Senate elections committees have told us that it is unlikely to move from where it is, it just appears that that bill is going to be staying right there like all the other ones.
And I'll add to that, next week is the deadline for, I believe next week is the deadline for non-fiscal bills to get out of committee. No, I'm sorry, that's first house. This one's in second house, so that wouldn't apply. Strike that. So it is currently pending with the Assembly committee, but it hasn't had a hearing set yet.
300, you're still speaking of 300.
Yes.
Yes.
Right. Let me just say for my part, I find it most unfortunate that nothing is happening with that bill. When this next election is all said and done, may we not come to rue the collective wisdom to not do anything about this particular bill. Thank you.
Thank you, Commissioner Cardenas. Commissioner Hatch, did you have a comment?
No, I had actually just was going to make the motion to change our position from sponsor to no position on was it 423?
423.
Yeah.
Senate Bill 423. All right, do we have a second to Commissioner Hatch's motion? Second by Commissioner Hayward. All right, do we have any public comment on this item? Seeing none, hearing none. Ms. Linker, could you call the roll?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Excellent. Anything further from the commissioners for our legislative team?
I have a question, Mr. Chair.
Commissioner Cardenas.
Do we know anything about what are or might be the contents of AB 2599?
Yeah, currently it's just a spot bill that I think changes chairman to chair or some very minor change to a section. It was being held to be used in the future, but it's not going to be moving forward as far as I understand. It hasn't been amended to a substantive bill, and I think they're at or past the deadline to do that.
Great. Any other questions or comments for our legislative team? Hearing and seeing none. Thank you, gentlemen. We'll move on to our item 16. These are our committee updates. First up is the Law and Policy Committee. We had I would say a pretty good meeting back on May 7th. We had a interested persons discussion on behested payments. We talked about Chief of Enforcement West presented some ideas which we thought were worthy of her continued consideration of regarding modifications to the Streamline program. I know we'll hear about those in June or July when they come back with the enforcement regs. And then also Mr. Bainbridge had discussed some ideas he had for our advice letter reporting process, which he'll talk about under item 18. So Commissioner Hayward, did you have anything of note that you want to mention?
Just that the interested persons aspect of the meeting regarding behested payments was, interesting and enlightening. The behested payments requirement gets a lot of criticism from people who have to comply with it. Some of that criticism is related to our interpretation, and then some of it, frankly, is related to the statute. And, we see in our legislative report that AB 3078, which would, narrow situations where reporting is required, won't be pursued, but those issues are still out there. So finally, my little soapbox thing would be that I felt like while people get very exercised about the behested payments issue, we didn't get a lot of specific feedback after our legal division had written an extensive memo that I think was largely very good, with 2.5 pages of potential changes to the behested payments regulation. I think I recommend that people read page 9 through 11 of that memo and come back to us with more specific responses to where they think the behested payments regulations need to go and what changes need to be made. It is sort of a backwater in some ways in terms of analysis. I think we're, as a jurisdiction, unique, or at least pretty distinctive in the fact that we even try and reach these at all. And so it's kind of a challenging place to try and figure out how to regulate, because we don't have a lot of sister states that do this to look to for examples or for other things like that. So the behested payments thing is coming back, and I hope that people will engage the advice that our legal division has given us, and so we can have the benefit of their experience. Thank you.
I could not agree more, Commissioner Hayward. Commissioner Hatch?
Thank you for that elaboration. It seemed to me, as one who practiced in the area for a long time, that this statutory provision is a bit of an overreach, perhaps because of its brevity and vagueness. The practice that was occurring before the legislation was passed was that of seeking out a member and offering to make a large donation through an intermediary to a charity of his choice, his or her choice, and then allow or arrange for that legislator to make or deliver the contribution, much as the prohibited provision relating to lobbyists delivering campaign contributions, so that the legislator could get full credit for the contribution. Now we're tangled up in the internet and mass mailings where often people are solicited to be either a nominal sponsor or a supporter of some charitable drive. that was never envisioned at the time. And I think that it might be helpful if the one thing that we could do that would be most helpful is if after we do all this analyzing and categorizing, we might be able to issue a report with recommended changes, statutory changes that we could report to the legislative leadership.
I think that's a good thought, Commissioner Hatch. I'm sympathetic to the fact that, you know, the statute, I think you're right in some ways, and Commissioner Hayward alluded to this. The statute leaves much to be desired in some ways. At the same time, I think we do have a clear obligation. It's part of the act. We need to enforce it. We need to interpret it. We need to implement it. And so I think, you know, our focus at this point really is on the regulatory piece, although I think you're right, Commissioner Hatch, we can certainly at least identify for the legislature some areas for them to consider when they finally determine to turn their attention back to Political Reform Act bills.
Thank you. Many of the problems that we have to deal with can't be solved with a regulation because it would conflict with the statute. So that was my thought as to how to solve this problem.
Do other commissioners have questions or comments on the L&P report? Hearing and seeing none, we'll move on to the Budget and Staffing Committee report. Commissioner Cardenas and I also had a meeting back in May. Our attention was focused on the job descriptions and the duty statements for the executive director and the legislative council positions, both of which we have now advertised and have received resumes for. And so I know he and I will be reviewing those in short order and reporting back to the commission at the appropriate time on those. So Commissioner Cardenas, did you have anything further you wanted to mention at this time?
Not at this time, Mr. Chair. Thank you.
Thank you. All right, we'll go ahead and proceed then to item 17. This is our third quarter expenditure report. Our acting, it's Ms. Hahn in her capacity as the Chief of Administration. You're pulling double duty these days. So you can keep track. Ms. Hahn.
Good morning, Commissioner. This is the third quarter expenditure report as submitted, unless any commissioner have questions for me at this time.
Any commissioner questions or comments on the third quarter expenditure report? Hearing none. Ms. Hahn, anything in particular that you wanted to bring to our attention?
Not at this time.
All right, thank you.
Mr. Chairman?
Commissioner Hatch.
Would this be a place to ask what's the latest in terms of activity referencing local governments contracting with us to provide services?
My understanding is that Ms. Hahn was going to address that as part of her acting executive director report.
Fine.
All right, thank you. All right, we'll then go ahead and proceed to item 18, our advice letter report. We have General Counsel Bainbridge. Oh, sorry, and we also have Assistant General Counsel Mr. Lau.
Should I start?
The floor is yours.
Good morning, Commissioners. I'm here to, again, answer any questions related to the advice letters identified on the advice letter report. Other than that, it's as submitted.
All right, do we have any questions or comments from commissioners for Assistant General Counsel Lau on the advice letters? Hearing and seeing none. Thank you, Mr. Lau, appreciate it. Mr. Bainbridge, did you wish to address the ideas that you had about our process for consideration of advice letters?
Sure, and it's actually Brian Lau's idea, so I'll give him credit for it, but I'll discuss it. And we talked to the Law and Policy Committee about it to get their input, and they were supportive. The current process is to place the advice letter report on the agenda as a separate item. That hasn't always been the way it's done. We started doing this about 2 years ago. My recollection is it was in light of some questions about whether we could take action on advice letters that had previously been contained in the legal division report. So we we took it out of there and made it its own item to make it very clear that this is something that could have action taken on it. What I'm proposing today is that we remove the advice letter report from the commission agenda as its own agenda item and instead make it a freestanding report that's issued at the end of each month. It would be in the same format as you see it each month on the agenda, but it would come out as its own report. It would be distributed to the commissioners, also made available to the public through our website and through our list service process. Then if there are questions, concerns, if it sparks a possible discussion, a commissioner could suggest or request that the particular letter be agendized for that next month's meeting. The benefits of this process, I think, is it provides better notice to everyone involved about specific letters that are going to be discussed. It allows commissioners to know what their fellow commissioners would like to discuss. It allows staff to be prepared, and it also allows the public or potentially the person who received the letter to have better notice that their letter will be a topic of conversation. As it is now, you know, there's 10 to 20, sometimes more letters on a report each month, I think. And as we saw today, sometimes there's no comments. Sometimes you'd like to discuss 2 or 3 letters. In my mind, it'd be a better process if the specific letters were agendized for discussion as opposed to the entire report. So my proposal is to have the legal division produce this report at the end of the month, allow commissioners to review it, and if they would like to request that a specific letter be agendized, that letter be agendized as its own item for discussion. And the report would then just be included as a link in the legal division report each month. That way, if anyone is used to finding it on our agenda each month, they could still find it through a link on our legal division report. But the opportunity for discussion would be by agendizing a particular item. And the law and policy, both the chair and Commissioner Hayward were supportive at law and policy, but they suggested that I bring it to the entire commission for consideration. It's not something that the commission needs to vote on because the chair sets the agenda for each commission meeting, but I know this has been an issue that all the commissioners were interested in. So the chair requested that I state it here so that there can be a discussion amongst the commissioners about this proposed process. Thank you, Mr. Bainbridge. Commissioner Hatch, you had a question?
Thank you, Mr. Chairman. Mr. Bainbridge, sounds like generally a good idea. I was interested in what you envision the timing. Does this mean we'll get to see him sooner or later than we currently do?
Yeah, I think it would be sooner. I think it'd be right around the end of each month. The report would probably cap off around 24th, 25th of each month. We need a couple days to put it together and then we distribute it.
Okay, that'd be great. We get more time to read them and pass our thoughts on.
Commissioner Hayward?
Yeah, and that's one of the things that appealed to me quite a bit about this. I mean, the efficiencies that Mr. Bainbridge has mentioned are true, but also I think it makes better use of part-time commissioners' time because we don't have the letters on top of everything else on the agenda to go through. I mean, speaking only for myself, I know I will have a better opportunity to actually think about what the letters say if I have them sooner than if they're bundled up with an agenda that might have, you know, several regulations on it, maybe a couple of STIPs that are controversial, and who knows what all. So, so I think this is a great idea, and I'm grateful that Mr. Lau thought of it.
Great. Other commissioners have questions or comments on this? All right, seeing none, I'll echo Commissioner Hayward's comments. Thank you, Mr. Bainbridge, and thank you, Mr. Lau. So we'll give this new process a shot starting next month and see how it works. So thank you. All right, so we will now move on to item 19, our executive staff reports. First up is Enforcement Division, Chief of Enforcement West.
Hello. Nothing else to add beyond the report. As you can see with the stay-at-home order, the number of complaints has gone down with the COVID situation. So that has given us some time to actually close out 157 cases with a lot of warning letters, no action letters, getting through a lot of the things that had been sitting. So, and that part has been positive.
Excellent. The commissioners have questions, comments for Chief of Enforcement West? Hearing and seeing none. Thank you, Ms. West. Appreciate it. All right, next up, Mr. Bainbridge, Legal Division report.
Yeah, I wanted to mention that all the new campaign manuals or the existing campaign manuals have been updated, and so they're on our website for public review and comment at this time. The commission will be seeing those in June for adoption approval. So we would encourage people who are interested to take a look at the manuals and provide us any comments or thoughts they have on those. You can find them on our website. I believe they're under the Learn tab, but if you have any trouble, just reach out to our advice email and we can point you to them. The other thing I'd like to point out is that we are conducting live virtual trainings, and that's been a program that our education group started, and it's been very successful. We've had great attendance on some of these live virtual trainings. So we have those that are performed live and as close as we can do to performing them in person right now. And then we also have video tutorials that are recorded that cover a number of topics, and we've seen quite a bit of traffic on those as well. So just encouraging people to go to our website and find these things. And if you're interested in scheduling your own virtual training, you can reach out to our folks and we'll schedule it if we can. With that,
thank you, Mr. Bainbridge. Commissioner Wilson?
Yes, General Counsel Bainbridge, in terms of the training materials that are offered by the commission, is there one spot or one location on the website where those are grouped and easily accessible?
Yeah, if you go to our main page, there's a tab at the top for Learn, and then from there you can pull down, and I think it's Training and Outreach, but it's pretty obvious once you get to the Learn tab, you can find the page.
Okay, that's perfect. Yeah, for the benefit of the public. Thank you.
Thank you, Mr. Bainbridge. Commissioner Hayward?
Yeah, I'm looking over the outreach and training report and see that apparently on May 13th, we conducted a Form 700 filing officer webinar that 450 filing officers had registered for. How did that go? I mean, that's a pretty big meeting.
Yeah, I haven't heard exactly how it went. I know that it happened and the attendance was around that number. So if I don't hear anything, I assume that means it went well.
I think that's a safe assumption. That's really impressive.
Yeah, I really, Mr. Bainbridge, I think the efforts and the work of the education folks really does need to be highlighted here. They're doing a great job. They continue to do a good job, and this is an area, and you heard it today when we were talking about item 3 with respect to compliance with the mass mailing requirements, et cetera. Utilizing virtual technologies like we are now, being creative in how we push out these trainings and increasing the number of trainings, I think is important to the commission. And so just again, I want to applaud the work of the folks in your division that are doing that. They should keep up the good work. We'll go ahead and at this point, go ahead and move on to Acting Executive Director Hahn and her Executive Director report.
Good morning, Commissioner Larissa Hahn. I would like to provide you some updates. The first is what Commissioner Hatch alluded to earlier about the local entities contract. So in the past couple of weeks, I have reached out to a couple of the entities that was interested to contract with us. And for one of them being City of Sacramento, they had a contract with us for for calendar year 2018 and 2019. And their contract ended on December 31st of 2019. So right before the pandemic, they had reached out to us to raise the interest to recontract with us. And I reached out to them, and they're saying that given the current budget situations and the Ethics Commission won't have a meeting until July, so they'll keep us posted after their meeting in July, if that occurs. And then the second thing I would like to update you on is on the post evaluations. So post sent us a letter indicating that the feasibility study is not necessary for us because of the area of enforcement that we're looking for. So they because that is not necessary. So we move forward of looking forward to get legislations. And I know that our communication director, Jay Waringa, is working on that with another state agencies to help us carry partial of the legislation to give us the authority. And the third and the last is the behested payment. There has been some question of us regarding our Form 803 portal on our website. There has been some question regarding if they were trying to file the electronic form, if the form was not filed successful, we will take the form that they filed the date as the date that they file. And our answer is yes, we will take people's effort of filing with us. If they're facing technical difficulties, all they require to do is send us an email addressing what their technical difficulties are, and we will take it as the date that they file. And that concluded my report. If any commissioner has any questions for me at this time.
All right. Thank you, Ms. Hahn. Commissioner Hatch?
Thank you, Mr. Chairman. Ms. Hahn, how many agencies do we now have under contract under this program?
Currently, we only have San Bernardino.
Okay, thank you.
Do any other commissioners have questions or comments for Ms. Hahn? Hearing and seeing none. All right, well, that concludes, for now, until item 22, our public session. At this time, we do have 2 closed session items. So why don't we take 5 minutes and we will convene in closed session at 11, let's call it 11:20. All right. Thank you, commissioners.
Hello, my video won't go.
All right, hold on.
We know what you look like.
Okay. I can operate that way, but I can't hear you.
Yeah. And my video doesn't seem to be up either.
Oh. Host asked me and I said, yes,
There you are.
I am. Thank you, host.
There we go.
Okay.
All right, we're just giving Commissioner Cardenas a second here.
Okay.
I apologize again for delaying you guys.
No worries. No worries at
Yeah,
all.
I made the bad decision to go into the other building where my kids are and get a drink, and I got immediately descended on. Why don't we have good snacks? We need to go into the store.
Once a week.
I know.
Once a week, that's right. All right, I think we're all back now. So we'll go ahead and reconvene again in open session following our closed session discussion. With respect to closed session item number 20, the commission has voted to accept the administrative law judge's proposed decision in the matter of Consumers for Choice, Tim Snipes and John Stoos, with some minor clarifying and technical amendments. In all other respects, the administrative law judge's decision is accepted as written. With respect to item 21, our personnel matter, the commission is reporting out of closed session that last month the commission voted to authorize the termination of our prior executive director, and that we are in the process of reviewing and evaluating a new executive director. That concludes the report out from closed session. We'll now move on to our last public item. It's item 22, commissioner comments on proposed future agenda items. Do any commissioners wish to speak on item 22? Hearing and seeing none, I will entertain a motion to adjourn.
So moved.
Second.
Second, Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Great. Thank you, everyone. Stay safe, and I'll see you guys next month.
Thank you.
Thank you. Take care.
Thank you, commissioners.